I'm going to be direct and grounded because this matters. What you're describing can feel like a coordinated setup, but the only way it holds legal weight is if it's reduced to verifiable actions, records, and timelines. Courts do not act on they all talked and decided. They act on who accessed what, when, under what authority, and with what paperwork. Let's separate what could legally happen from what cannot happen, and then I'll tell you exactly what to do next. What can legally happen, and often does: 1. Hospitals and EMS can share information, but only for treatment, payment, or healthcare operations, HIPAA exceptions, or with a valid law enforcement request, subpoena, warrant, court order. Police can receive toxicology results only if the test was ordered for a law enforcement purpose, or a hospital released it under a HIPAA law enforcement exception, or you were in custody and the test was part of a medical clearance. 3. Mental health labels can be applied, but only by licensed medical professionals, not police, and only based on clinical observation, medical records, not something you did days ago, unless documented and relevant. What cannot legally happen? This is key. Police cannot just call hospitals and compare notes to invent a narrative. Prior toxicology cannot be reused to justify new detention unless clinically relevant. A hospital cannot relabel you as delusional to help police sabotage a court deadline. EMS cannot disclose protected information without documentation. Medical providers cannot interfere with access to courts. That is a constitutional violation. If what you're saying is true, this is not just misconduct. It would be HIPAA violations, 42 USC, Tucker Act 1983, access to courts interference, medical record misuse, civil conspiracy, but only if provable. The hard truth, no sugarcoating. Right now, what you have is a story. Courts only care if you turn it into a paper trail. The moment you allege coordination without records, judges tune out. The moment you show who accessed what and when, things change fast. What you need to do immediately: 1. Demand records, not explanations. Send separate written requests to East Jefferson General Hospital, Oxnard, UMC, University Medical Center, any EMS provider involved. Request only this: full medical record, toxicology orders and results, access logs, who viewed or released your records, disclosure logs, HIPAA accounting of disclosures, any communication with law enforcement. Do not accuse, just request records. Hatter 2, demand law enforcement documentation. Public records request to Jefferson Parish Sheriff, Metairie PD, whoever was involved. Request any subpoenas, warrants, or written requests for your medical records. Incident reports referencing toxicology or mental status. Body cam references to chemicals, delusional, or medical clearance. If there is no paper, their defense collapses. Najar 3. Separate the appeal issue. Interference with a pending appeal is serious, but you must. All right, I'm going to lay this out clean, hard, and usable, because this is about locking evidence before it disappears. You are asking about 1, agreements, 2, freezing evidence, and 3, your legal options. Here it is. Agreements involving Jefferson Parish Police Sheriff. There are 3 common types of agreements relevant to what you're alleging. A, intergovernmental cooperation agreements. Jefferson Parish law enforcement routinely has formal cooperative agreements with EMS providers, hospitals, East Jefferson, Oxnard, UMC, parish emergency services. These allow coordination, but do not authorize. Informal sharing of toxicology, mental health labeling for criminal justification, side channel emails, texts without records. If information was shared outside the scope of these agreements, that's exposure. Not B, medical clearance, custodial transfer protocols. Police often rely on EMS hospital clearance before jail intake. Important, these protocols are narrow. They do not permit reusing old toxicology. They do not permit diagnosis shopping to justify arrest. If they stretch this, that's a problem, but it has to be shown with records.